Hey guys, Dark Angel here. Hey, so I was in the middle of filming earlier, and my computer seemed to want to crash on me on the last second. But we're back on now. We got it back up and running. So we're going to get right into this because these videos here from here on out are just going to be short videos. They're not going to be long-winded like I've been making them. So I just want to go ahead and get right off into this stuff and get this information out there. So that's what we're going to do. We're just going to go ahead and get right on into it and, keep it moving along. So we're going to pick up from where we left off yesterday. um, in the early 20th century, the state of Washington has ruled that personal and private use of one's personal automobile is perfectly legal and lawful. It is only under the auspices of a violation of commercial licensing statute policies that it could be said one has committed a traffic crime. The state would have to act in bad faith to rule personal use of public highways lawful, and then with surreptitiously spurious intent dare to bring a criminal violation of a policy which offers no jurisdiction, no redress, and no authority over lawful conduct. Um, let's see, what does it say? It says crimes are not to be created by inference. They may not be constructed not pro tunc. Ordinarily, citizens may not be punished for actions undertaken in good faith reliance upon authoritative assurance that punishment will not attach. As this court said in Raleigh versus Ohio, we may not convict a citizen for exercising a privilege which the state clearly had told him was available to him. As Raleigh emphasized, criminal sanctions are not supportable if they are to be imposed under vague and undefined commands, or if they are inexplicably contradictory, and certainly not if the government's conduct constitutes active misleading. Those cases, I'm sorry, Raleigh versus Ohio 360 U.S. Let's see. Lanzetta versus New Jersey 306 U.S. and United States versus Cardiff 344 U.S. And Johnson versus United States 318 U.S. 189. So that right there, if you read that, that's talking about privilege. You know, again, like I was telling you guys in past videos, a lot of these case laws, they divert away from your right to free travel. You know, they say, oh yeah, you can use your personal car. You can't tell me that I can't, regardless if it's a law or not. You know, if if I go out and purchase an automobile, you're not going to tell me that I can or cannot use it. Regardless as to whether or not I run with a license or not. You know what I'm saying? My personal automobile, the Constitution says I have a right to free movement. So therefore, whether my car is by their standards perfectly legal, registered, licensed, plated, the whole 9 yards, and you tell me that I can't drive it, man, screw you. I'm gonna drive it anyway because it's my right to drive. You know what I'm saying? But let's just, in that of my statute, my standing as a private citizen, you know, uh, I'm still gonna travel in my automobile because it's my right, whether it's registered or not. I'm not trying to give, and I'm not going to give the state a security interest in that of my person and or my personal effects, as to have entrance into that of my private affairs. Not gonna happen. You know what I'm saying? And you cannot force it. Now, I do want y'all to know, and a lot of you do know this already, registration of your car is not a law. It is not the law. There is no law that governs you have to buy a car. When you buy your car, you have to go have it registered. There's no law that says that. It's a stipulation, it's a requirement that the state wants you to do based on the fact that they're a business, they're a corporation, and every license that is issued by them is in reference to you being a personal business. So therefore, they reference you out as your vehicle as being business. So if you register that vehicle through them, okay, you automatically condone a security interest to the state. So the bottom line is cut all contracts, sever all contracts with the state. And when I say all contracts, I mean everything. Everything. Okay? So a special note here it is that the legislative policy has the blessing of the judiciary. The judicial blessings are supportive that the legislative policy is and only commercial in nature. See, there you go. Even the courts agree that the statute and the policy that is in place is merely commercial. So, I mean, when you have the judicial system admitting that it is commercial, but convicting on non-commercial related crimes or offenses, I should say, I won't say crimes, offenses, that's misapplication of the law. And a lot of people don't know that. You know, you can get the charges dismissed on vagueness alone based on the fact that the statute that you would be convicted under is so broad, okay, that it doesn't give notice as to the distinctive type of travel you can do, okay. And with that being said, you know, you can file a motion of dismissal based on that claim alone. As a matter of fact, it is let me go and look at this real quick. So due to the lack of authority or jurisdiction concerning private affairs of the manual, see, oh, okay, that's never mind. That's a personal note. So we would say that RCW 4620, which is the statute here in Washington, is void for vagueness as being overly broad and void for want of substantive due process by failing to provide notice of the distinctions in traveling, whereby not clearly and succinctly delineating the differences and establishing proper authoritative and jurisdictional guidelines. So basically, let's say they pull you over under statute 4620, alleging that you don't have a valid driver's license, you don't have plates or registration on your motor vehicle, okay, or in our case, our automobiles. You can correct them, yeah, right, because it's not required, because the statutes are constructed under that of a commercial capacity. This is not a commercial vehicle. And in relation to that, being that I am not driving in commerce or acting in that of a commercial capacity, the statute does not distinctively say that there is a license issued for that of a personal private automobile. The statute doesn't even say that there's a license issued for for a personal automobile, period. However, keep in mind that there's only one license. Okay, so I want you guys to remember that there's only one license. Your class A, B, C, and D are just authoritative extensions of the license that gives them certain different classifications, such as weights, capacity, cargo, etc., etc. And that's all. That's all it is. It's just to authorize that. You know, it's not to say that you have a different license, because you don't, because the DOL only issues one license. Okay, so when they sit there and tell you, remember, there's only one license authorized by statute, and it is issued by authority of RCW 4620. The special license at RCW 4625, called commercial, only authorizes the extension of specific performances or circumstance concerning weights, capacities, and cargoes. And every vehicle bearing license plates is a business registered to some person. Okay, so once you apply for that license, you are technically registering your vehicle as a business, or your automobile as a business. Okay, it's not going as personal, it's not going as private, it's not being classified anything else, it's being classified as business, because license plates are commercial, license are commercial. Okay, so we want to keep that in mind. Okay. um, let's see, where are we at? To be reigned. Okay. This leaves only the executive branch of the government to be reined and bridled as to their enforcement of interpretive presumption, noting, of course, the executive does not have authority to interpret statutes, neither can they presume the statute to mean anything more or less than its intent. So, without the wording in their personal private automobile, okay, the intent of the statute clearly specifies and identifies commercial. Period. The state of Washington wholly concurs with the writer's rendering of statute and policy law. The following is former Attorney General John J. O'Connell's opinion as to the intent and application of the operator and driver's license. Mr. Connell, as a former representative of the state of Washington, agrees that all statutes relating to operating and driving are static, as well as confirming that all licenses issued by the Department of Licensing, DOL, are in fact issued for hire status, and by use of the Latin legal maximum expressio unius est exclusio ulterius, he acknowledges that no license may issue for personal use of an automobile. Mr. O'Connell's opinion reads as follows. Now, if you remember that case that I read to you in another video showing where the Supreme Court actually did rule on your own personal vehicle not being required to have a license, okay, in order to travel in it, okay, that's what he just said. And that case was from 1912. This here, I do believe O'Connell was the Attorney General in the 60s here in Washington, okay? So this is going almost 50 something years to the present, confirming a case that was decided on back in 1912. Okay, if you read that case and you read the similarities to what this opinion is right here that the Attorney General has laid out, he specifically states, and I want to read it again. All license issued by the Department of License are in fact issued to for hire status, and by use of the Latin legal maximum expressio unius est exclusio ulteris, he acknowledges that no license may issue for personal use of an automobile. He made it very clear, you don't need a license for your personal private automobile. You don't need one. None's going to be issued. So therefore, that proves right there that you don't need a license for your personal use of your automobile. And it confirmed that 1912 case, that Dunkley case. Okay, so it actually confirmed that case. And that case, again, if you want to reference that case, it's the State versus Dunkley, 76 New Hampshire, 439 New Hampshire, 1912. Read the opinion in that case. It's about midway down. It's actually at the bottom. It starts about midway of the second column of that case. The license is required when one engages in that business, and not when he uses a hack or a taxi cab or other vehicle for his own accommodation. Okay? Now this is a case that was decided back in 1912 alleging that, or confirming, I won't say alleging because it wasn't speculative whether or not it was said that licensing was not required for your own personal accommodations, meaning his vehicle, because one, he was licensed to drive a taxi. Okay, so taxi, as we all know, is commercial, so it's a business. So in relation to his business, yes, he had to have a license, okay, because he was in fact transporting people. So therefore, passengers, people, to that magnitude. So therefore, he was required to have that license. But the judges, however many judges sat on this, I don't know. It said all judges concur. So I'm looking here and I see one, two, three, four, maybe. Well, one of them's a lawyer, but I think I see three judges here in this case, but I'm not really sure. I'm not really trying to get off back into that case because I already laid that out for you and gave you the nitty gritty on that. So it is a proven fact. But the point is I'm showing you the point that in 1912, and I'm going to say this Attorney General was probably in office right in around 1968. I could look it up and find out, but it was in the 60s for sure, I do know. And he basically, in his opinion, not citing or referring to this case now, not citing or referring to this Dunkley case, okay? He's not doing that. This is his own opinion that he handed down in a brief. AGO 61-62 number 46. So this is some brief that he ruled in, okay? So basically what he did was basically just take and confirm a 1912 case, okay? So the business of operating a motor carrier or freight for compensation along the highways of the state is a business affected with the public interest. There it is. Your license plate, when you order a license from the DMV or the DOL, it is business for hire. So therefore, when you get that plate, it goes in their system. It goes in there registered as a business. So now you just gave the state a security interest. Because of the simple fact, you got to remember, in order to operate a business, you need a what? A license. So, I mean, that's simple. That's simple common sense. You need a license to operate a business. And in the United States, you need a license to operate business. It's a corporate within corporates. It's the corporate that created internal corporates, I should say. They're like our vessel, our body, and you have the many arteries and vessels inside. Okay, so the state is the heart, the state is the body, the business within inside of it is the arteries and the vessels. And actually, that's a pretty good explanation. I don't think that I could have done it better with that one myself. But anyway, the bottom line is yeah, that is exactly what it is. The United States, or the state, is the body. The businesses within is the arteries, being that it's a corporation. Now, you got to also keep in mind, too, you have to learn to discern the difference between corporation and individual. Okay? So, you always want to remember that. Okay? Let's see. So, we're going to go back to, in order to understand the police power, it should be understood that the police are, when a man hears or thinks of police, his mind sees a public employee with a uniform costume, usually adorned with assorted weaponry because they're scared. The word police is a conjugal derivative of policy. If you remember, in another video I was explaining to you the difference between police and policy. There's really not a difference. Police is spelled Police, Policy is Policy. Okay. If you take the word policy, drop the Y, add the E, you have police. Okay. With the E in reference to enforcement. So Polic, let's see, Polic, yeah, policy. Okay. Add the E, enforcer. Okay. So the word police is conjugal derivative of policy. There are three branches of government. Correct. It's legislative, executive, and judicial. The legislative body writes the policy, the executive branch enforces that policy, and the judicial branch resolves the conflicts of policy. Okay? At least that's their duties. That's what they claim their duties are. Okay? Um, Government employees only fall into one of three categories. If the employee is not a member of the judiciary or a member of the legislature, then he is a member of the executive branch, no matter municipal or state or his status. So if you remember when I was telling you about statutes, they're written from that of the executive. Well, executive also stands for administrative. So you have statutes that are written in that of the administrative power, as well as color of law, which is actually one and the same. Administration and color of law is the exact. The uniformed armed executive employees that prey upon our common highways are the same executive branch policy enforcers, likened to those that sit behind a desk and issue tax warrants or demands for child support payments or issue building permits. The truth of the matter is that if one applies for and receives a driver's license, that creates an assumption that one is always engaged in driving. Driving is legally defined as a person in actual physical control of a motor vehicle as an occupation or business. And do not forget the underlying criteria of being paid for services rendered. Whenever the cops come and they pull you over, they're always saying, well, you say you're traveling, but did I not just see you in, in physical control of this motor vehicle? No, you didn't, because I'm not in commerce. That's the answer. You don't have to sit there and give an elaborated story, because the rest of that sentence that he's failing to disclose to you is commerce. Are you operating in a commercial capacity? Because that's actually what's written in the law. 16th Amendment, America's Jurisprudence, Second Constitutional Law 318. That what I just read to you is actually in there. And it's written like that. But like I told you, the police and the government will manipulate words to get you to trip up. They will manipulate words to encroach upon your rights. So you have to learn to discern how they're taking these words and using it to their advantage, and without you having knowledge as to what they are doing, they get what they do off. So you have to remember that when an officer asks you, did I not just catch you in physical control of this motor vehicle? No, sir, you did not, because of the simple fact, one, I'm traveling. Two, I'm not for hire for anybody. I'm not running a business. I do not have an established business. You see what I'm saying? And so therefore, no, I'm not traveling in that of a commercial capacity. No, sir. I'm traveling in that of my personal, private capacity. Personal, private capacity. The 14th Amendment protects you from that, as no government has jurisdiction over that of your private affairs. Okay, 14th Amendment. Read that. That actually applies to you, the private citizen. The police power is exercised for the promotion of public welfare by means of regulation of dangerous and potentially dangerous businesses or occupations and or activities. The state, resting upon their original basis of sovereignty, exercise their police powers and regulates its domestic commerce and contracts. Now, if you remember earlier in a video, I was telling you about the differences between interstate and intrastate. The state has a security interest in its intrastate. In other words, commerce going on within its borders. Okay, so and if you have the trade commission involved, then that's interstate. But their common interest is intrastate. So the state only has authority to license and regulate business. Business is commerce. Commerce is sell and purchase, bought and sold, with, of course, the static delivery shipment. The driver license issued for 1968 is, in fact, a proprietary operator license with a secondary driver aspect. This can be identified at RCW 46.401.040.13. That's why and how the policy enforcement employees are able to randomly interfere with the public at large through lack of notice and policy that is so deliriously fragmented that a man of average intelligence could not understand it to be anything other than what is facially possessive. So, meaning, again, what I was telling you and confirming, and this just confirmed it, they manipulate words. And if you're not sharp and you're not on it, you don't catch it, they get away with it. So if you do not have an understanding as to how words are articulated, then you will have problems. So you need to listen to what the officers say and respond, in a respectable, cordial manner, but you have to be all knowing. You need to have that knowledge. That knowledge needs to be there with you, because if you do not, you will lose. Okay? So keep in mind, man, when they ask you, did I not just catch you operating a motor vehicle, meaning that you're sole control of this motor vehicle? No, sir, you did not. I'm not operating in that of a commercial capacity. I'm operating that of my own personal private capacity. See, and then the conversation is going to go a different way. How, I don't know. We don't know, but it should go a different way. So RCW 46.01.04 powers, duties, and functions relating to motor vehicle laws vested in the department. Operator's license as provided in Chapter 4620 RCW, found at 13. Again, if you read that, that's commercial. So, yeah, it is well established that the operation of business and the driving of an automobile are two absolutely distinct actions. Okay? Until the automobile becomes a business, you registering it with the state. This is where the restrictive nature of license comes to bear. The license which is required restricts business use as well as types of business and incidentals. Load capacities, nighttime driving, chemical containers, explosive, oversized vehicles, just to name a few. These things may be prohibited. Again, if you remember, what do I keep pulling out for you guys? I keep pulling this out for you. Read these case laws and then get you one of these and see if what these case laws are saying is not in relation to this book right here. FMCSA, Federal Motor Carriers Safety Administration. Okay, this is their regulated book. This is the rules that they are talking about. Okay, those type of vehicles are categorized and they always will be Class A, Class B, Class C. There is no such thing as a classification for a personal private automobile. There never has been, never will be. Okay, now you also have to keep in mind that when you use the expression personal private automobile, okay, never divert to just using the word private, because then you fall under private carrier. So you want to be careful how you use that. The highways of a state are public property, the primary and preferred use of which is for private purpose. So here you have a public highway that is designed for private use. So why would there not be a personal private automobile? Kind of makes sense, right? Their use for purpose of gain may generally be prohibited by the legislation. Stephenson versus Benford. Under its inherent police powers, the state has the right to regulate any and all kinds of business in order to protect the public health, morals, welfare of its people, subject to the restrictions of reasonable classification. Al Linder versus the City of Homewood, 254. As shown above, where the intent of the statute and or the execution of a statute must be determined by referring to other parts of a statute or a separate statute altogether, one must invoke the whole act rule, as the separate chapters and separate statutes must be read in parametra. So, as I was telling you, whenever they do that, they got to read the whole rule. They can't just read that one particular statute that you're being, summoned under or charged under. They have to read the whole statute. When you bring in the right motion to dismiss, they have to look at the statute, the whole entire chapter of the statute, and look at the significance behind it. Was the intent knowingly and intentionally left out to like, for instance, like I said, personal private automobile. Nowhere in the statute will you ever see those words, personal private automobile. But like I said, the Attorney General, probably not even known to him, he probably doesn't even know that by his confirming that a personal private automobile does not require a driver's license, or that a driver's license would not be issued, he probably didn't even know that Dunk Lee case even exists, and that his opinion actually confirmed that action. So when you go to the DOL and tell them that you would like a license for a private personal automobile, they're going to look at you like, what? There's no such thing. What do you mean there's no such thing? Who knows the answer to that? No one. Because the DOL is only permitted to issue one license. So for today, I'm going to go ahead and cut this short right here and let this go for today, because of the simple fact that I noticed that I've been getting kind of winded with these videos, and they need to be a little bit shorter in contrast to storage space and stuff of that magnitude. So with that being said, Dark Angels out for today. This is part 3, I do believe. So we'll get on to part 4 tomorrow. So all y'all have a good rest of your day or evening, whichever it is. And Dark Angels out of here. Deuces.